I'm Doreen So.
And I'm Sanaya Mistry.
Welcome to How on Estates. You're listening to episode number 619. How are you today, Sanaya?
I'm doing very well. How are you, Doreen?
I'm good. Today we'll be discussing a case called Rudin-Brown. It is a case from the Superior Court of Justice. It was released this May in 2021. It's a case about a SDA matter. It has to do with who is the valid substitute decision maker for an incapable person. There are POAs being challenged. POAs were changed sort of like three years apart. New wills were made. The incapable person lives with only like one person in the family. And there are actually some really interesting evidentiary issues that arise in this case. And I think a bulk of our discussion is going to be on that piece of it. And it has to do with the spicy topic of audio recordings. Before we get to like the meat of that, Sanaya can give us a bit of context and background for this case.
Yes, absolutely. So in this case, we have Carolyn Brown, who is a 91-year-old woman who is the incapable. She had wills and powers of attorney executed in 2009 and recently had a new will and power of attorney executed in 2016. When you compare the 2016 and the 2009 testamentary documents, you see the difference in the two is quite drastic. In 2009, she had appointed her sister-in-law, Jean, as her power of attorney for property, and had appointed her daughter, Missy, and her son, Gordon, as her attorneys for personal care. In the 2016 powers of attorney, this has changed. In 2016 now, Gordon is her attorney for property as well as personal care. With respect to her wills, in 2009, Jean was the executor of her will, and her residue was to be divided equally between Gordon, Missy, who is her daughter, and Zachary, who is her daughter Sandra's son. In the 2016 will, Gordon is now the executor and also the sole beneficiary of the residue of her estate. So there are significant differences between the two documents.
And so in the context of Carolyn's family at 91 years old, you can kind of see like maybe just how dramatic this like change in family dynamics even are. Just if you put yourselves in Carolyn's shoes, she is the mother of 3 children, Missy and Gordon, who are still alive. One of her daughters have been predeceased. Like you have a prior will where everybody was still like treated equally in a per stirpes fashion. But, jump to 2016, the son, the only person who lives with Carolyn in her house, sort of, rent free, is now the one completely in control of Carolyn's power of attorney, property, and personal care. And at the end of the day is, at least on paper, on the will, going to inherit everything. And Janine, Carolyn's sister-in-law, someone in Carolyn's own generation who, presumably she had relied on in the past and had a close relationship with the past, is also no longer in the picture. So all of that casts like quite a bit of, suspicion in sort of like the universe of this proceeding. Carolyn, I think, like in the decision, it refers to, everybody, I think, like the different parties had different, had put Carolyn's decline at sort of like a different stage of things. Some said she was, starting to have good days and bad days much earlier. Gordon, of course, said it started like much later. But at the end of the day, before they actually got to, the hearing of this application, for the time when the judge is to decide which one of these documents are, the valid ones, Carolyn had actually been in 2018 really been declared as incapable for both property and personal care. So with that in mind, this decision was incredibly important because, you already have an incapable individual. And so if she's incapable and all the documents that she had in place are in question, who is going to take care of her? Gordon, of course, wanted to be the one who remains in charge. And Janine and Missy were the applicants in this proceeding who wanted to sort of turn things back to them because of all their concerns that they raised about Gordon. And, given the long history and perhaps like the family dynamics, it seems like Gordon may have been aware that that this might come up like at the end of the day or sometime in the future. And he apparently started to record Carolyn's phone. He put recording devices attached to, her home phone. There were instances where, like tape recorders were found in Carolyn's purse while she was, say, like out and about with like Missy or Jean. And the evidentiary issue that I mentioned at the beginning, they came up because Gordon actually wanted to tender a lot of these tapes for the truth of what Carolyn was saying. And from Gordon's perspective, this was apparently the only way for Carolyn to have like a voice at the proceeding. It was Gordon's way of showing that Carolyn supported his role in her life. But on the other hand of things, Missy and Jean didn't know they were being taped at the time. A lot of those recordings actually took place with like phone calls between like them and Carolyn. They weren't all just like, calls with Gordon and Carolyn. But they also actually thought part of those discussions were helpful to them. So they wanted to rely on some of those recordings too. So then, the court was put in a position to really actually consider the admissibility of these recordings, even though neither side was pushing them out like that vigorously, because each side wanted to rely on some part of it in support of their own case. So, maybe Sanaya, what were your thoughts on how Justice Williams went about this tricky problem?
I thought the decision was very informative and very interesting. The way that it has been explained as to what considerations were given in terms of the admissibility of these recordings was a fascinating read. Something that I found to be interesting was that in the decision itself, Justice notes that the recordings of Carolyn and Missy's conversations, although perhaps obtained illegally, doesn't translate into inadmissibility directly. There are other considerations that need to be considered to decide whether something like that should be admissible or not. It also found that, these recordings had been edited by Gordon. And they were edited in a way where only the things he thought were relevant were admitted into the evidentiary record, but the things he did not think were relevant weren't. And something to point to in the decision was, irrespective of that, if these recordings were not admitted, then the judge pointed out that they wouldn't have access to the entire evidentiary record, and that was something that they put some weight to.
Yeah, this is a really interesting case that like goes through quite a bit of the legal analysis from a very much like a first principle basis, and then gets really into like the nitty gritty as to why like the judge came to like his conclusion at the end of the day, because the test on what is or is not admissible evidence at a hearing is very much based on like a weighing analysis of what is probative versus its prejudicial effect. At the end of the day, the court only wants to hear and consider anything that is actually relevant proof to the issues at hand. But at the same time, they have to like weigh all of that probative value, if it's there, against its prejudicial effect on all the parties involved, as well as even in like administration of justice. Because one of the comments was just that you might have some probative evidence like at hand, but if the court has to like sit through a year's worth of recordings, then that might be in itself too prejudicial to have any of that come through. The other part of it actually really was what was truly prejudicial at the end of the day in this decision is that Carolyn having been declared as incapable of property and personal care, despite having Section 3 counsel in this matter, she did not participate as a witness in this proceeding. So, in the parties putting forward things she was recorded as being said, and the judge being asked to find the truth of what she was saying in the tapes as what she actually really wanted or felt at any given time. The court really considered just how prejudicial that may be for Carolyn, because you can't really actually ask her now if these recordings actually represented what she wanted, right? She has no opportunity to give the court the context as to why she may have said XYZ. There was also, a huge, privacy component, really thoughtful, actually findings of fact as to whether or not she actually truly consented to being recorded in the first place. Because Gordon, when he explained how all these recordings came about, just sort of seemed to have described a conversation where, Carolyn said yeah, go for it. But it happened for such a long period of time, knowing, her condition and, just her level of awareness, on a day-to-day basis, every time she picked up that phone, the court really found that there's no way there's anything that really shows in a reliable manner that she actually agreed to being recorded during every single one of these conversations that are being tendered. If anything, one of these conversations showed that she had mentioned to the person she was speaking to, oh, I shouldn't talk about this right now. I'm afraid he is going to hear, with reference to Gordon, which showed the court okay, well, if she's afraid to say it on the phone because he may be physically around, that shows that she doesn't know that he's actually can listen without being physically around, because he's recording everything. So the idea that these recordings stands for Carolyn's voice at the trial, the judge did not give credence to that agreement. But in terms of it was still admitted, it was still part of the record, because it does show the conversations between the parties, and at the end of the day, very little weight was given to what Carolyn said. But for the parties and how they were able to be cross-examined on the things that they have said on the phone, the judge was able to rely on those statements and the cross-examination of those statements. And I think he also found on just that it was in a way evidence of Carolyn's relationship with each and every one of these individuals, because at least it is evidence that they have been speaking, some evidence of the frequency of their conversations and maybe the depth of them, but didn't necessarily go so much to the core of exactly who Carolyn may have wanted to be her guardian or POA at the end of the day. So it was a very nuanced treatment of these recordings, absolutely worth a read. And I think earlier on you mentioned that it was, there is a criminal aspect to recording people without their consent. It's not part of the admissibility analysis for evidence at common law and civil litigation, but at the end of the day, anybody who is considering maybe capturing some of this evidence from their loved ones to be really mindful of the fact that it is prohibited under the criminal code to intercept a call without the consent of the people on the phone. And it could be interpreted as an interception when you are just there without anybody's knowledge during that telephone conversation. And the court also does a really good job of reminding everybody that at the end of the day, the courts do really discourage this type of evidence gathering. It seems to happen quite a bit in family law. And the reason being is that it's probably quite disruptive to, interpersonal relationships, privacy is huge here. Everybody like should be able to say whatever they want to this person like on the other side of the phone without any fear that it's like being listened to by literally anybody else for any purpose whatsoever. And I think another really big take home at the end of the day is that the fact that Gordon did this, the fact that consent was quite questionable in this regard, this invasion of privacy, it didn't help him on the back end. It didn't help him, in garnering the court support. That it's in best interest of Carolyn that he remain in control of, all of her care for property and personal care for having done this in the first place. So ultimately, the court did invalidate those later 2016 POA documents. And the court did a little something different. He didn't just fall back onto like the old POAs in 2009, because Gordon is still one of two personal care attorneys in 2009. What happened was there was like competing guardianship applications from like both sides, and Janine remained as the guardian of property. And the difference, what ended up being at the personal care stage, where Missy and Jean were the guardians of personal care, didn't go back to the 2009 personal care attorney for personal care. All of this is like really good, like food for thought for litigators, be it at like sort of the SDA stage or even at the estate stage, because there is like sort of like that Venn diagram of the tests in terms of like validity of like this type of like document, be it for POAs versus wills, like there is like all of that overlap here. That the same like evidentiary comment definitely applies to a testator once they are no longer with us. We talk about Section 13 of the Evidence Act quite a bit in terms of like requiring corroboration of a person who's deceased if anybody is to obtain a judgment against them. And the same exists in Section 14 of the Evidence Act, just one section below. Same corroboration is required for when a person has been declared to be like incapable. So definitely worth the read. So it's a great case. Thanks for discussing it with me. That concludes our podcast. Until next time, we want to thank you for listening. I'm Doreen So.
And I'm Sanaya Mistry.
Should you have any questions, please email us at info@hollandhealth.com or leave us a comment on our blog. Thanks.
Thank you.